Morning, everybody. Happy New Year to everybody. This meeting is called to order. Mr. Drummond, has anybody signed up for public comment?
Morning, Commissioners. Les Drummond, General Counsel. We have two individuals who have registered for public comment this morning. When I call your name, if you could go ahead, unmute yourself and introduce yourself and begin. First, we have Emily Rivera.
Good morning. My name is Emily Rivera, and I am the claimant in this case. Thank you for the opportunity to speak. This is regarding written testimony in support of motion for rehearing and confidentiality request. I, Emily Rivera, submit this written testimony in support of my motion for rehearing following the Texas Workforce Commission's denial of my commission appeal on October 27, 2025. This motion is timely filed. Confidentiality request pursuant to the Texas Family Code of 93.003, the Public Information Act, Government Code Chapter 552, and other applicable confidentiality laws, including official state and local governing agencies. I request that all personal identifying and sensitive information related to this case, including contact information, financial data, payroll records, medical and other agency documents, and case details to remain confidential and not to be disclosed to the public or third parties. Grounds for rehearing: new evidence and error. Accurate wage calculations were not possible at the time of the initial filing due to employer payroll errors, including underpayments, incorrect pay rates, inaccurate overtime, improper deductions, and missing or incorrect payroll records. These errors occurred from December 6, 2021 through December 22nd, 2022. My employment began December 13th, 2021 and ended April 6th of 2022. My pay rates fluctuated without consistent notice and were not accurately reflected in payroll records. $16 at higher, $15, $16.35, $17, with changes effective March 1st of 2022. Some payroll stubs do not reflect correct hourly rates of salary adjustments. These inaccuracies prevented accurate wage reporting on my claim submitted on April 15th of 2022. Corrected information later obtained constitutes new evidence that materially would affect the decision. Employer and agency error: the employer failed to maintain and provide accurate payroll records as required by Texas Labor Code 61.019, including records of pay rates, straight time and overtime earnings, and deductions. Pay was variable and consistently issued. Complete records were not provided during the initial investigation and became available only after the decision. Relief requested: I do request, or respectfully request, that the Commission grant this motion for rehearing, conduct a full review and investigation, compel production of complete payroll records, and issue a preliminary wage determination pursuant to Texas Labor Code 61.052. A rehearing is necessary to ensure a fair and accurate outcome. The wage miscalculations resulted in denial of unemployment benefits and severe financial hardship for which relief is warranted. Thank you.
Thank you. Next, we have Caleb Jones-Timms.
Good morning, Commissioners. My name is Caleb Jones-Timms. I am the claimant in case number, give me 1 second to pull up my notes. I'm sorry. I am the claimant in the case number 3934951-2. I am appearing today to briefly restate the procedural concerns that led to the reinstatement of my case, and to respectfully request that those concerns result in reversal of the appeal tribunal decision. At the tribunal level, the employer failed to appear at the continued hearing. Despite the absence, the hearing officer developed and relied upon lines of reasoning not argued by the employer. While material issues I raised, particularly regarding contradictory testimony from the June 12th hearing about who processed my termination and whether any alleged misconduct was personally observed, were left unresolved. Those procedure irregularities affects the fairness and neutrality of the hearing itself, not merely the outcome. When credibility conflicts go unaddressed and the record is supplemented by reasoning not presented by a party, the decision cannot rest on substantial evidence. Following my public comment on December 16, 2025, the commission determined that further review was warranted. I respectfully submit that the same concerns that justified reinstatement also support reversal, or in the alternative, corrective action that fully remedies the due process defects in the record. I am also experiencing documented hardship, including loss of housing, which makes timely and fair resolution critical. I would also like to emphasize burden of proof and legal sufficiency. The employer bears the burden to prove misconduct. Where there was no employer participation at the continued hearing and no cited policy established the violation. On this record, the legal standard for misconduct was not met, warranting reversal. I would also like to emphasize the scope of authority. The issue is whether the tribunal findings were supported by evidence presented by the parties. Where the hearing officer developed theories not argued by the employer and left credibility conflicts unresolved, the decision exceeds proper adjudicative bounds. Reversal is the appropriate corrective action. Because the employer did not meet its burden and the record lacks supplemental evidence of misconduct, reversal is warranted. Remand is appropriate only if the commission believes additional neutral fact-finding is required. I appreciate the commission's careful review and respectfully request that the final decision expressly address these procedural issues and reverse the tribunal's ruling accordingly. Thank you for your time.
Thank you. Those are the comments we have this morning.
Thank you, Mr. Troman. Now turn the meeting over to Commissioner Connett to preside over agenda items 3 through 8.
Thank you, Chairman, and good morning, Ms. Miller. I understand that we have no cases to reconsider under agenda item 3. Is that correct?
Correct, no cases.
Very good. Moving on to agenda item 4, tax liability cases. Good morning, Mr. Daniel. I understand we have no tax cases on dockets 53 and 1, but we have one tax case on docket 52. Is that correct?
For the record, Hugh Daniel, Special Program Appeals. That is correct, Commissioner Connett. There's one tax liability case on docket 52 and no tax liability cases on dockets 53 and 1. The case number on docket 52 is TD-25-010-0825. Chairman Esparza.
I agree with the recommendation.
Commissioner Trevino.
I agree with staff's recommendation.
Commissioner Connett.
Agree with staff recommendation.
Thank you all. That concludes tax liability cases for these dockets.
Thank you, sir. On agenda item 5, we have no fair housing cases to consider. Is that correct?
Correct, no cases.
Moving on to agenda item 6, I understand we have no child labor cases on dockets 52, 53, or 1.
Correct, no cases.
Very good. Agenda item 7, wage claim cases. We have no wage claim cases pulled for additional discussion on dockets 52, 53, or 1. Is that correct?
That's correct. No cases pulled for additional discussion, but you should have received the wage claim short form dissent list for dockets 52, 53, and 1.
I move that we accept staff recommendations on the remaining wage claim cases on dockets 52, 53, and 1.
And I second the motion except for those cases which I am dissenting, as reflected on wage claim short form dissent list for dockets 52, 53, and 1.
I concur with the chairman's motion, except for the cases in which I am dissenting is reflected in wage claim short form dissent list for docket 52, 53, and 1.
The motion passes with the exceptions noted. Moving on to agenda item 8 in the consideration of unemployment insurance cases on dockets 52, 53, and 1. Please proceed with docket 52 when you're ready.
Thank you, sir.
Case number 3666040. Commissioner Trevino.
The AT decision is not supportable. The claimant resigned his job following the end of his medical leave because the working environment had not changed. The claimant was unwilling to return to work to working conditions that had caused his illness. The claimant submitted medical documentation supporting his testimony that his medical conditions were caused by a working environment, and the employer did not appear at the hearing to refute the claimant's testimony that he had spoken to the employer about the working conditions and that the employer refused to make any reasonable accommodations to allow him to continue working. Therefore, the claimant had good cause connected with the work for quitting due to his medically verifiable illness. Reverse the AT, no voluntary leaving, bill reimbursing employer, no overpayment.
The AT's decision should be affirmed. The claimant did not return to work after his leave of absence, and after this, he submitted a letter of resignation that became effective the same day. As such, the claimant voluntarily left his position of employment without good cause connected to the work. Thus, we should affirm the AT decision, voluntary leaving, reimbursing employer, not billed, overpayment.
The claimant should be disqualified for voluntary leaving, and the employer's account should not be billed because the claimant resigned due to medical reasons without completing the medical accommodation or FMLA processes that he had become extremely familiar with. Therefore, affirm the AT, voluntary leaving, reimbursing employer not billed, overpayment.
Short form dissent, ma'am.
Yes, sir.
Case number 3678934. Chairman Esparza.
The AT decision should be reversed. The claimant was terminated for improperly processing credit card applications. The employer stated the claimant knew that the person applying for credit cards had to be in person or had to be present to sign the application. The employer also stated that the claimant admitted to processing applications for people who were not present. Claimant contends she had permission from prior managers to handle the credit card applications in the manner that she did. However, as an assistant manager, the claimant should be held to a higher standard and should have asked the manager that was in place at the time of the final incident, whether she could continue processing applications the same way. As such, the claimant's action constituted misconduct connected with the work. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision is correct. The employer discharged the claimant for processing store credit card applications for family members. The claimant provided credible firsthand testimony that she had been authorized by 2 prior managers to complete these types of applications, as long as she had the approval of the family members, and that she and her coworkers had been doing this for the past 6 years without any correction, and that this only became an issue when a new store manager came in. Since the employer permitted the claimant to process credit card applications for family members without warning over the past 6 years, and was directly told by her previous store managers that this practice was acceptable, the employer condoned the claimant's actions, and she was discharged for reasons other than misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The claimant should be disqualified from the receipt of benefits. The claimant engaged in misconduct when she negligently signed and processed store credit card applications on behalf of others who were not present. Instead of reporting this practice to upper management, the claimant continued to engage in behavior that clearly violated the employer's prohibition on falsifying company documents. Modify the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3707014. Commissioner Trevino.
The decision is not supportable. The claimant registered at 1:05 p.m. for the AT1 hearing, which was scheduled for 1 p.m. due to a misunderstanding about the registration process. The claimant's late registration was caused by her confusion about the hearing process, and because she had previously spoken with the hearing officer on 2 prior occasions and believed that she was registered. When the claimant realized that she was not registered, she called in immediately to participate, but was not allowed to do so. Since the claimant made a good faith effort to participate in the hearing, but was only a few minutes late in registering, good cause should be granted and the case resubmitted for merits testimony from AT1. Modify the AT, claimant established good cause for AT1, resubmit.
The AT decision should be affirmed. The claimant failed to attend the scheduled hearing due to a misunderstanding the hearing instructions. As such, the claimant was not prevented from participating due to circumstances beyond her control. As to the job separation, the claimant resigned without allowing the employer to without an adequate opportunity to address her final complaint. Accordingly, the claimant quit without good cause connected with the work. We should therefore affirm the AT decision. The claimant did not have good cause for non-appearance, voluntary leaving.
This case should be resubmitted for the underlying merits testimony to be summarized. The claimant established that she reasonably believed she was already registered for the AT1 hearing. Moreover, the claimant made a diligent effort to correct her mistake and timely file an appeal, modify the AT, good cause, resubmit.
We will resubmit the case.
Case number 3733020, Chairman Esparza.
The AT decision should be affirmed. The claimant was discharged for violating a company policy he was aware of. After receiving a final notice about his attendance infractions, the claimant continued to accrue additional infractions. The claimant relies on an 8-minute grace period to substantiate that not all infractions were valid. However, the employer's testimony establishes that the grace period does not apply to early departures, as front desk coverage is needed in this workplace. As such, the claimant's action violated the employer's policy and constituted misconduct connected with work. So we should affirm the AT decision, misconduct, reimbursing employer not billed.
The AT decision should be reversed. The employer testified that the claimant was discharged for violating its attendance policy by accruing more than 2 attendance points in a 30-day period. However, the claimant and the employer both testified that the claimant was specifically told by his supervisor that he had 1 attendance point as of 2/28/24, since the claimant's early departure that day was within the allowed grace period. The claimant's late arrival the following day only accrued half point under the employer's policy. Therefore, the claimant had only accrued 1.5 points. The employer's allegation that the claimant had additional points prior to 2/28/24 and that the early departure was not subject to the grace period were not credible due to the inconsistencies in the employer's testimony. The employer failed to establish that the claimant violated known policy and was discharged for misconduct connected with the work. Reverse the AT, no misconduct, bill reimbursing employer.
The claimant should be disqualified from the receipt of benefits. The claimant engaged in misconduct when, despite warnings, he was successfully absent in violation of the employer's attendance policy. Affirm the AT, misconduct, reimbursing employer not billed.
Short form dissent, ma'am.
Yes, sir.
Case number 3744497, Commissioner Trevino.
While the claimant filed her appeal to the AT after the deadline, this case involves a continued claim related to the claimant working as a marketplace contractor in self-employment. As such, there was no separation from employment and the continued claim should be voided. Timely claimant appeal, set aside AT decision, void the continued claim.
The AT decision should be affirmed. The claimant filed her appeal beyond the applicable deadline to be considered timely, and there are no good cause exceptions to the timeliness rules. As such, the claimant's appeal should be dismissed as late. We should therefore affirm the AT decision, untimely claimant appeal, voluntary leaving, overpayment.
This case should be remanded to collect testimony on the entire record so we can better analyze whether the merits affect the timeliness issue. The available evidence on the underlying issue suggests that the claimant may have worked 1 week as a gig worker while searching for other work. This could mean that the claim is void from its inception, in which appeal time limits would not apply. So therefore, remand for underlying merits testimony.
Ma'am, I'll agree with Commissioner Connett.
Short form dissent.
Yes, sir. We will remand that, and I have your short form dissent.
Case number 3765447, Chairman Esparza.
The AT decision should be affirmed. While on a period of leave, the claimant failed to provide the employer's third party with the required medical documentation to support her leave. Thus, the claimant mismanaged her position of employment. Affirm the AT, misconduct, no chargeback. In the alternative, because the claimant stated that her leave of absence resulted from a medical condition, she could modify the AT decision under medical separation analysis. Therefore, modify the AT decision, no misconduct, no chargeback, MVI.
The decision is not supportable. The employer discharged the claimant for allegedly failing to submit FMLA paperwork by the given deadline. However, the claimant had worked diligently to deal with her mother's various medical conditions and her own bout with pneumonia, all while trying to get multiple doctors to fill out the necessary FMLA paperwork. The claimant submitted all the paperwork that she had to the employer's third-party administrator by the deadline. However, due to lack of communication between the employer and the administrator, it was determined that the claimant had not submitted all the necessary paperwork. The employer's testimony was inconsistent, while the claimant credibly established that she had both provided the medical documentation and consistently notified the employer of her absences. Therefore, the claimant's discharge was not for misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The claimant should not be disqualified from the receipt of benefits. The claimant's absence was primarily due to compelling personal reasons in having to care for her ill mother. Moreover, the claimant testified under oath that she properly notified the employer of her absence. Therefore, modify the AT, no misconduct, no chargeback under the urgent and compelling analysis, memo to investigate availability.
I'll agree with Commissioner Connett.
Thank you. And the vote is no disqualification, no misconduct. Did you wish to dissent on any portion?
I would dissent on the chargeback, I believe.
Thank you, sir.
Yes.
Case number 3805310. Commissioner Trevino?
While the claimant filed her appeal to the AT after the deadline, this case involves a continued claim related to the claimant's working as a marketplace contractor in self-employment. As such, there was no separation from employment in the continued claim, and the continued claim should be voided. Timely claimant appeal, set aside the AT decision, void the continued claim.
The AT decision should be affirmed. The claimant filed her appeal beyond the applicable deadline to be considered timely, and there are no good cause exceptions to the timeliness rules. As such, the claimant's appeal should be dismissed as late. We should therefore affirm the AT decision, untimely claimant appeal, voluntary leaving, overpayment.
We should resubmit this case to summarize the entire record so we can better analyze whether the merits affect the timeliness issue. The available evidence on the underlying issue suggests that the claimant may have worked one day as a gig worker while searching for other work. This could mean that the claim is void from its inception, in which appeal time limits would not apply. So resubmit to summarize the underlying merits testimony.
I'll agree with Commissioner Connett.
Thank you. We will resubmit the case. That was the last case pulled for discussion on docket 52. You should have received the UI short form dissent list for docket 52.
I move that we accept staff recommendations on the remaining UI cases on docket 52.
I second the motion, except for those cases which I am dissenting, as reflected on UI short form dissent list for docket 52.
I concur with the Commissioner's motion, except for the cases on which I'm dissenting is reflected in UI short form dissent list for docket 52.
The motion passes with the exceptions noted.
Thank you, sir. Proceeding to docket 53.
Case number 3706064. Chairman Esparza?
The AT decision should be reversed. Here, the claimant was on notice that his job was in jeopardy after being moved to a different store location due to his inappropriate conduct. Despite this, the claimant continued to engage in behavior so egregious that various subordinates at his new store complained, as evidenced in the record. The claimant's behavior and actions toward subordinates constitute misconduct connected with work. As such, we should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision is correct. Although the employer discharged the claimant based on allegations that he made inappropriate comments to coworkers, the employer did not present any firsthand testimony to support the allegations against the claimant. The claimant has consistently denied the employer's allegations under oath. Therefore, the employer did not meet its burden of showing that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The claimant should be disqualified. The weight of the evidence suggests that the claimant mismanaged his position of employment by making inappropriate comments to his coworkers after he had been previously after he had been previously suspended for similar behavior. Modify the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3758334, Commissioner Trevino.
The decision is not supportable. First, I agree that the claimant established good cause for missing AT1 since he did not receive the hearing notice. Regarding the job separation, the employer discharged the claimant, alleging that he violated company policy by interviewing employees that he had previously referred. The claimant provided credible firsthand testimony denying under oath that he had violated any company policy or personally knew those people referred for interviews. Additionally, while the employer did allege that the claimant altered attendance points for other employees, the claimant testified that he had discretion to edit attendance points for employees that were unable to call the attendance hotline. Therefore, the employer did not meet its burden of proving that the claimant was discharged for misconduct connected with the work. Reverse the AT, claimant established good cause for AT1, no misconduct, chargeback.
The AT decision should be modified. First, I don't contest the good cause issue. Second, the record establishes that the claimant engages in numerous violations of the employer's policies. The employer provides evidence of the claimant interviewing people he referred to the company, amounting to a conflict of interest given his HR role. The claimant's conduct constitutes misconduct connected to work. We should modify the AT decision. The claimant had good cause for his non-appearance, misconduct, no chargeback.
Good cause should be found and the claimant should be disqualified. The employer submitted sufficient evidence to show that the claimant mismanaged his position of employment by interviewing and hiring individuals whom he referred. Modify the AT, good cause, misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3783705, Commissioner Trevino.
This case involves an additional claim related to the claimant working as a marketplace contractor in self-employment. As such, there is no separation from employment and the additional claim should be voided. Set aside the AT decision, void the additional claim.
The AT decision should be affirmed. The claimant was having ongoing issues with his mode of transportation. And as this company requires employees to furnish their own vehicles, his lack of transportation amounted to a voluntary quit without good cause connected to the work. Thus, the AT decision should be affirmed, voluntary leaving.
The claimant's honest reporting of gig work earnings should not trigger a new claim and result in the claimant being disqualified from the receipt of benefits. The claimant's work as an independent delivery contractor for a marketplace platform was not an employment. Thus, there is no separation and the underlying ruling is void. Set aside AT, void additional claim.
Short form dissent.
Yes, sir.
Case number 3850095, Chairman Esparza.
The AT decision should be affirmed. Here, the claimant resigned from his last work, and prior to this, the claimant had not received the physician's recommendation to resign. As there is nothing in the record to suggest his reasoning was with good cause connected to the work, the claimant voluntarily left his last work without good cause connected to the work. We should therefore affirm the AT decision, voluntary leaving, reimbursing employer not billed.
The AT decision is not supportable. The evidence established that the claimant resigned for medical health reasons. The employer had advised the claimant that it was not safe for him to drive due to the state of his mental health, and his doctor advised him to take time off from work. Therefore, the evidence established that the claimant had good cause to resign from work due to a medically verifiable illness. Reverse the AT, no voluntary, bill the reimbursing employer. In the alternative, I could agree to rehear this case to further develop the record on whether the claimant's separation was due to a medically verifiable illness. including asking the claimant if he has medical documentation to present and whether he was advised by his doctor to resign.
The claimant should be disqualified. The weight of the evidence suggests that the claimant voluntarily quit due to health concerns without first advising the employer of his concerns or attempting to seek reasonable accommodations. Additionally, the claimant has not shown that it was medically necessary for him to quit. Affirm the AT, voluntary leaving, reimbursing employer, not billed.
Short form dissent, ma'am.
Yes, sir.
Case number 3850245, Commissioner Trevino.
The AT decision is not supportable. The claimant was qualified for benefits based on a layoff from his full-time job. A few weeks later, the claimant took on a part-time food delivery job, which paid well below his commission-established wage demand and only offered sporadic hours. After trying to work this job for a little over a month and only earning a total of $414, the claimant decided that he had to quit because of the impact the work was having on his medical conditions. The claimant provided evidence of various medical conditions that he was dealing with, and it was reasonable for him to conclude that he had to leave this job for health reasons. Therefore, since the separation was directly related to the claimant's medically verified illness, he should not be disqualified from receiving benefits. Reverse the AT, no voluntary leaving, no overpayment.
The AT decision should be affirmed. The claimant quit due to medical reasons. However, the claimant did not provide medical documentation to establish that a medical professional advised him to quit his job. In addition, at the time of the claimant quit, he stated that he was not seeing a doctor or his psychiatrist. As such, the claimant resigned without good cause connected with the work. Should therefore affirm the AT decision, voluntary leaving, overpaying.
This case should be remanded to obtain evidence as to whether a partial separation occurred during the week of this continued claim and to determine whether the separation should be analyzed under section 207.045G1 of the Act. Therefore, remand.
Ma'am, I can agree with Commissioner Conant.
Thank you. We will remand the case.
Yes, ma'am.
Short form dissent.
Short form dissent, sir. Yes, sir.
Case number 4006490, Commissioner Trevino.
Yes, ma'am. The AT decision should be reversed. The claimant resigned her position because of a medical condition involving her vision that was exacerbated by the constant computer use that was required by her work. The employer's argument that the claimant could have requested accommodations in order to keep her job was not pervasive, and the employer was made aware of the claimant's medical conditions and offered no accommodations and admitted that all of the positions in the department required all-day computer use. Since the claimant quit due to her medically verifiable illness, the claimant had good cause connected with the work for quitting. Reverse the AT, no voluntary leaving, bill reimbursing employer. However, if my fellow commissioners do not agree that the claimant should be qualified based on the available record, I would agree to rehear the case in order to admit the claimant's medical documentation into evidence. As the documents were available to the hearing officer, but not previously entered into evidence, and further question the parties regarding the claimant's medical restrictions.
The AT decision should be affirmed. The claimant quit due to medical reasons. However, the claimant did not submit documentation establishing that a medical provider advised her to quit her job, nor did she submit documentation stating that she was under any medical restrictions. In addition, the claimant stated that she did not request accommodations or seek another type of work from the employer. As such, the claimant resigned without good cause connected with the work. We should therefore affirm the AT decision, voluntary leaving, reimbursing employer, not billed.
The claimant should be disqualified from the receipt of benefits. Although the claimant had legitimate health concerns, she resigned before requesting technological accommodations or a transfer. As such, she did not give the employer an opportunity to remedy her concerns. Affirm the AT, voluntary leaving, reimbursing employer not billed.
Short form dissent.
Yes, sir. And that was the last case pulled for additional discussion on docket 53. You should have received the UI short form dissent list for docket 53.
I move that we accept staff recommendations on the remaining UI cases on docket 53.
I second the motion except for those cases which I am dissenting as reflected on UI short form dissent list for docket 53.
I concur with the commissioner's motion, except for the cases on which I'm dissenting is reflected in UI short form dissent list for docket 53.
The motion passes with the exceptions noted.
Thank you. Proceeding to docket 1.
Case number 3711953, Commissioner Trevino.
The AT decision is not supportable. The claimant was hired to work a fully remote position and did so for nearly 3 years. Then the employer informed the claimant that he would be required to report to work in the new office every day. Since the claimant had always worked remotely, and since the new office was 50 miles away from his home, the claimant informed the employer that he was not in agreement with this change, but that he wanted to continue his normal job duties. The employer responded by telling the claimant that they were accepting his resignation immediately and sent people to pick up his company truck. Since the employer substantially changed the claimant's hiring agreement, the claimant's refusal to comply with this change did not constitute misconduct connected with the work. Reverse CAT, no misconduct, chargeback, void adequate response.
The AT decision should be modified. The employer discharged the claimant after the claimant was ordered and then refused to commute to the office. As this transfer into the office would not substantially reduce or change his wages, the claimant was discharged for misconduct connected to the work. As such, we should modify the AT decision, misconduct, no chargeback, sever adequate employer response.
The claimant should be disqualified, and the claimant's refusal to comply with the employer's reasonable instruction to report in office, a request that was not substantially different from the claimant's previous job duties, amounts to insubordination. Therefore, modify the AT, misconduct, no chargeback, sever adequate employer response.
Short form dissent.
Yes, sir.
Case number 3786052, Chairman Esparza.
The commission should grant a rehearing in this case. In its appeal to the commission, the employer states that it was told by a TWC representative that as long as the employer appealed on a certain date, everything would be fine. Since the employer's appeal to the commission indicates that it relied on information from a TWC representative that everything was fine, the commission should grant a rehearing to take testimony from the employer regarding information it received from a TWC representative.
The AT decision should be affirmed. The employer filed their appeal several weeks after the appeal deadline because the owner was out of the country and had not designated anyone to monitor the employer's email or mail in her absence. The employer's later contention that their appeal to the commission and that the appeal was late because she was told that she needed to submit evidence by a certain date and then everything would be fine is not persuasive, as the allegations was inconsistent with the employer's prior appeal and testimony, and because it involves the initial investigation of the claim, not the later appeal. Since there is no good cause exception to the timeliness rules, the employer's appeal should be dismissed as late. Affirm the AT, late employer appeal, no misconduct, chargeback.
Concur with Chairman Esparza and vote to rehear.
We will rehear the case.
Case number 3786306, Chairman Esparza.
The AT decision should be reversed. As the only party to the hearing, the employer provided sworn testimony, taken under oath and subject to cross-examination, that the claimant was fired for negligence and insubordination. The AT decision itself notes that the claimant made several mistakes in her work, including sending incorrect prescriptions and typos in patient letters. Ensuring prescriptions are correct before sending them and avoiding typos did not immediately present as tasks that require an extreme level of difficulty. Moreover, the final incident consisted of the claimant not being able to make any evidence that she made proper scheduling for surgery despite having been instructed to do so. As such, the claimant's actions reflect negligence rather than working to the best of one's ability. and constitute misconduct connected with work. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. The employer discharged the claimant because after being employed for 6 months, she was still unable to perform the job task to the employer's satisfaction. The employer testified that the claimant was trying to compete or complete the work and provide no evidence that the claimant was not working to the best of her ability. But despite this, she was not able to perform the job as required. Therefore, the employer alleged that the claimant became upset by her inability to perform the job. Both the employer's prior statements to the commission and their testimony established that the claimant was discharged because she was not able to learn the job, which does not constitute misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The claimant should be disqualified. The claimant negligently failed to perform simple job tasks such as sending medical documentation to the wrong patient, not sending her supervisor required weekly reports, and not copying her supervisor on emails as instructed. Modify the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir. That was the last case pulled for additional discussion on docket 1. You should have received the UI short form dissent list for docket 1.
Ma'am, I'd like to move that we resubmit case number
Oh.
3764832 so that it can be reviewed further and then placed on a later docket.
Case number 3764832.
832.
And I need a second vote on that. Or resubmit. There needs to be a majority.
I won't support.
I'm sorry,
I won't support.
no? And
No,
no.
I respectfully decline to resubmit.
Okay, unfortunately, no majority to resubmit that case.
Okay, that was for that first public comment, but thank you.
Yes, sir. Any other motions before we move on? Thank you.
I move that we accept staff recommendations on the remaining UI cases on docket 1.
I second the motion except for those cases which I am dissenting as reflected on your short form dissent list for docket 1.
I concur with the commissioner's motion, except for the cases on which I am dissenting as reflected in UI short form dissent list for docket 1.
The motion passes with the exceptions noted.
Thank you.
That concludes our business on agenda items 3 through 8. Chairman Esparza, I hand the meeting back over to you.
Thank you, Mr. Connick. We will take a short break and break for the shuffle. Thank you. Let's conclude. We are at agenda item 9 regarding acknowledgement of gifts and donations of $500 or more in value given to the Workforce Commission. I think, here you are. Hi.
Hello, Chairman, Commissioners, and Mr. Randy Townsend. My name is Natasha Ray, and I'm an attorney in the Office of General Counsel, and today I'm presenting to you gifts and donations received by TWC for your review and approval. State law allows TWC to accept gifts and donations of money, services, and property that further the lawful objection of the agency, as long as they're not prohibited by law, such as from a prohibited source. Furthermore, state law and TWC policy require that gifts and donations over the value of $500 be accepted by the commissioners in an open meeting, along with the donor's name, the amount, and the purpose presented in the public record. Today, I have 3 gifts to you paid by third-party entities. 2 of these gifts were for travel reimbursements for employees, and the 3rd gift is for the use of parking spaces. The donations have been presented before Interim Executive Randy Townsend for his initial acceptance, and his acknowledgement and approval are provided for you in the document. If you have any questions, please let me know. Thank you.
Commissioners, any comments or questions?
Nothing here.
No comments or questions. Thank you.
Thank you, Natasha. Thanks for the transparency. Do I have a motion?
Chairman, I move that we approve the acceptance and acknowledgement of gifts and donations to the Texas Workforce Commission as presented today by staff.
I second the motion.
I also vote yes, and the motion passes. Thank you.
Thank you.
Item 10, regarding publication for public comment of proposed amendments to 40 Texas Administrative Code, Chapter 819. Mr. Reed O'Brien.
Hey, good morning, Chairman Esparza, Commissioner Conick, Commissioner Trevino, and Mr. Townsend. For the record, my name is Reed O'Brien with the Office of General Counsel. Commissioners, before you today for your consideration for approval are proposed rule amendments to Chapter 819 Civil Rights Division. This rulemaking will align the rules relating to employment discrimination training with current federal guidance provided in Executive Order number 14281 issued in April 2025, and it will clarify the definition of disability as it relates to the Texas Property Code, Chapter 301, and its use in the Texas Workforce Commission Rules, Chapter 819, subchapters G through L. Additionally, staff completed a statutorily required review of the rules in Chapter 819, and this proposed rule will serve as public notice of the review in accordance with Texas Government Code Chapter 2001. Staff recommends submitting the proposed rule for publication in the Texas Register for a 30-day public comment period, and staff also requests the ability to make minor non-substantive changes to the document to comply with publication requirements of the Texas Register and the Office of the Secretary of State. That concludes my comments. I'm available for any questions.
Thanks, Reed. Commissioners, any comments or questions?
None here.
No, thank you.
Very good. Do I have a motion?
Chairman, I move that we approve the proposed amendments to Chapter 819 Civil Rights Division for publication for public comment as recommended today by staff.
I second that motion.
I also vote yes. Motion passes. Thank you, Reed.
Thank you.
Agenda item 11, regarding a request from the U.S. Department of Health and Human Services to extend federal child care and development relief fundraisers. Allison.
Right. Good morning, Chairman, Commissioners, and Mr. Townsend. For the record, Allison Wilson with the Child Care and Early Learning Division. Today, you have before you a discussion paper regarding the extension of 2 existing federal CCDF waivers that Texas has in place. These waivers were to provide TWC with additional time to implement new provisions added to the CCDF federal regulations. The Office of Child Care has notified states that they may request extensions for these waivers. The following 2 waivers require extensions and corresponding amendments to Texas's CCDF state plan for fiscal years 26 through 28. The first is a waiver of the requirement to provide child care services through some grants and contracts for direct services. ACF's recently proposed rules amend the regulations to return flexibility to states and remove this requirement. Services provided via grants and contracts will remain allowable at board option under TWC rules and Texas statute. The second waiver is of the requirement for the parent copay to be capped at 7% of family income, regardless of the number of children in care. TWC has already been implementing this provision, but we would like to request additional time to fully implement. The 7% copay cap is being implemented on a rolling basis as families are redetermined eligible for child care services, and some families have had their redeterminations extended. Staff recommends the commission approve these two waiver extensions as outlined in the discussion paper. That concludes my remarks, and I'm happy to answer any questions.
Thanks, Allison. Commissioners, any comments or questions?
None here.
No, thank you.
Very good. Is there a motion?
Chairman, I move that we approve the Child Care and Development Fund waiver extensions and corresponding amendments to the CCDF state plan as described in the discussion paper and recommended today by staff.
I second that motion.
I also vote yes. Motion passes. Thank you, Allison.
Thank you.
James, come on up. Item 12, regarding approval of the selection of decisions for the AEL Distance Education Professional Development Center. And James.
Good morning, Chairman and Commissioners, and Mr. Townsend. For the record, I'm James Golson with the Workforce Development Division. Today, I'm presenting the RFA selection decision for the AEL Distance Education Professional Development Center. Briefly, the purpose of this RFA is to create a statewide DEPDC that will deliver distance learning and remote learning training, technical assistance, and capacity building services for AEL grantees. The evaluation team received or reviewed 2 eligible applicants, and a single winner was selected for the full available award of $1 million. Grants are anticipated to begin in June of 2026. This morning, staff recommends approval of one award in the amount of $1 million for the AEL Distance Education Professional Development Center. Be happy to answer any questions y'all might have.
James, commissioners, any comments or questions?
Nothing here.
None here.
Is there a motion?
Chairman, I move that we approve one grant award for the Adult Education and Literacy Distance Education Professional Development Center in the amount of $1 million as described in the discussion paper and recommended today by staff.
I second the motion.
I also vote yes. Motion passes. Thanks, James.
Thank you.
Then item 13, board nominees.
Good morning, Chairman, Commissioners, and Mr. Townsend. For the record, Kara Levy, Workforce Development Division. Today, for your consideration, we have board nominations for the following boards: Workforce Solutions East Texas, Workforce Solutions Golden Crescent, Workforce Solutions Northeast Texas, Workforce Solutions Permian Basin, Workforce Solutions Texoma. Staff presents these nominations for your consideration, and I'm happy to answer any questions you have.
Thank you. Commissioners, any questions?
None here.
No comments or questions. Thank you.
Is there a motion?
Chairman, I move that we approve the local workforce development board member nominees presented today for the following: Workforce Solutions East Texas, Golden Crescent, Northeast Texas, Permian Basin, and Texoma.
And I second the motion.
I also vote yes. Motion passes. Thank you, Kara.
Thank you.
Appreciate it. Item 17, Michael Britt, nothing. Okay, I do believe we have an executive director's report for item 18.
Yes, good morning, Chairman, Commissioners. Just wanted to bring you up to date on just high level the response to our direction we received from the governor's office on the child care fraud prevention and detection. I know each of your offices have been receiving information about the actions that have been taking place over the last week or so. And obviously we have a couple of reports that will be due later, one later this month on a progress report and then into February. And just wanted to make sure that everyone was aware that all the cross-divisional efforts underway, child care, fraud detection, and our finance, and among other areas, to make sure we're staying focused on this effort. And staff is doing a fantastic job. We're having several meetings, communications with, including providers and all the stakeholders, and as we move this forward. But it's on a very quick, fast-paced track to make sure that we're doing the type of due diligence that needs to be done to make sure the child care program is being addressed in terms of fraud prevention and detection in particular. But just want to make sure that I knew you know that, but thought it makes sense just to make sure that publicly we're all on the same page on this. So that was it this morning. Thank you.
Great. Randy, thank you. I also want to commend you and Reagan and Allison and Chris, Michael, everybody who kind of worked tirelessly to respond and work with all of our stakeholders. Yeah, we're hearing it. We're going to continue to listen, and we're going to continue to layer to make sure that we're getting good traction on making sure all these tax dollars are going to where it's needed. It's a very, very precious resource that goes to our providers, that goes to our parents, and it's going to be heavy this legislative session. So quick response is definitely appreciated to our legislature and to our parents and to our providers. So thanks again for that. Early in the year. Very good. Fall item, we're at agenda item 19. We're going to break for executive session, and I've got to say the magic words. The time is now 10:55. Texas Workforce Commission is now going to executive session to discuss the appointment, employment, and duties of the executive director, internal auditor, executive staff, and other personnel pursuant to Government Code, Texas Government Code 551047A1. Don't go away. We're going to meet in that room. I forget what it is. Time is now 11:01. The commission met in executive session beginning at 10:55. Uh-oh, Gary.
I think that's what it was. Yes.
Yep, 10:55. And concluded at 11:01. I make a privileged motion that we appoint Steve Peer to serve as the Texas Workforce Commission Executive Director effective February 1st of 2026 at the ceiling of Group 7 salary for the administrative head of the agency.
Chairman, it's with great enthusiasm and optimism that I second the motion. I look forward to working with Mr. Peer on the agency's ongoing efforts on efficiency and effectiveness, ensuring the public trust and integrity are maintained in the expenditure of public funds, and of course, innovation for this agency and for the future of the Texas workforce.
I'll agree with the motion.
Good. Motion passes, and we've got a new executive director. With that, I'd like to thank everybody's, especially those who applied in the state, out of state, everywhere we've got, especially our internal applications. We appreciate everything that we've done. Our HR office, thank y'all for your support, and our general counsel's office to support this as well. So we look forward to having our new executive director start February 1st of 2026. And in the spirit of bringing on great talent, I want to introduce Nuhan Nafsan is our new intern in the office of our commissioner's office of employers. So Nuhan, thank you very much for joining us. He comes over from UT. So we got another UT student that's coming over here. And y'all, I've known him for just like a little bit of yesterday. And I think Allison met him yesterday. We came in over there for our deal. Very bright student. Already, he got a hell of a handshake, y'all. And it has some great questions. So if this is any indication of his generation, the kids are all right. So thank you. Look forward to having you and continue. We're going to be bringing him all over the place. He just basically said he wants to learn about government. So it sounds like he's got a public servant's heart. So we appreciate that. It's a lot of fun. He's sitting in my office. So if anybody wants to come talk to him, just come on in. Except for you guys, you'll have to make points. Okay, everybody, thank y'all. Is there a motion to adjourn?
Chairman, I move to adjourn.
I second.
All righty. Motion is made and seconded. We are adjourned. Thank y'all.